Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. In their reply to the state's response to defendant's motion in limine number 7 regarding witness identification by bushy eyebrows, this is available on the docket today, the 26th of March. It was filed by the defense on the 24th, and we have a major piece of evidence never before seen by the public, as well as details that have not been divulged to the public until now. First, if you go to page 3 of this reply brief, you will note that in this third interview of DM, she is one of the two surviving roommates. On November 17th, 2022, DM was interviewed by Detective Gooch, who asked DM if she knew what a baklava was. This is another term for a ski mask, sort of piece of clothing that covers the head and the face and only reveals a portion of the face. And Detective Gooch at that time showed her a picture. DM drew the mask for the interviewer. A copy of DM's drawing is attached, and this is it here. Now, what else is the defense saying in this in limine motion, reply to the opposition that has been filed by the state of Idaho? If you go to page 2, the argument, mistaken identification have been one of the leading causes of wrongful conviction in the United States for decades, and still are. When a witness swears under oath to the identification of the person on trial, the impact cannot be understated. And this must be the defense addressing the impact on the jury. In this case, defense argues if DM is allowed to say that she saw bushy eyebrows, it will not only be different than her pointing to Mr. Kohberger and saying that is him. To make matters even more prejudicial, the state wants to admit into evidence a picture of Mr. Kohberger as if DM identified him in the photo. This is how wrongful convictions occur, according to the defense. They go on. The photo of Mr. Kohberger that the state attached to its response is not relevant, and it is overly prejudicial. This is akin to the state trying to identify Mr. Kohberger for DM or create its own corroboration for her. DM previously said that she could not identify him. There are literally millions of people in the world who might be described as having bushy eyebrows. The term itself is subjective. That means it's not hard and fast. It's open to interpretation based on the person who is making an identification by bushy eyebrows. This is the crux of the defense argument here. The defense goes on. The state contends that DM's statements are independently reliable, as law enforcement did not employ a witness identification procedure. Mr. Kohberger is not suggesting DM's descriptive words were developed in conjunction with a lineup. DM was interviewed 5 times. Law enforcement was involved with each interview. According to the state, DM's multiple descriptions of the, and in parentheses, intruder, were based on her own recollection and were not the result of suggestive identification procedures employed by law enforcement. Mr. Kohberger now points the court to the following instances, which he says are suggestive. Number 1, in the second interview on November 13th, DM was interviewed in the police department by Detective Mowry, who inquired about facial features and asked DM if she knew what color the intruder's eyebrows were. Detective Mowry is the person who mentioned eyebrows, not DM, is what defense argues here. 2, in the third interview on November 17th, 2022, DM was interviewed by Detective Gooch, showed her a picture, and this is the exhibit that you will find to this filing, drawn by DM. The state argues that DM is a reliable witness. The defense shows that this motion in limine must be granted, and they give reasons why, such as it should not ignore either the limited amount of time that DM had to view the intruder or her state of intoxication. So they're stating here that DM was in a state of intoxication. Next page, DM saw the intruder briefly in a dark hallway. In her own words, she was probably, quote, very drunk and tired when she saw the intruder at 4:00 a.m. Then the filing continues, and we now learn for the first time, if we go to page 6, in this case, not only was there an 8-hour delay in reporting prior to the first law enforcement interview, DM was allowed to mingle with BF and many other friends. Law enforcement did not separate all of the friends who came to 1122 King Road prior to interviews, and no warning was given to not discuss the facts, and no other effort was made to limit such a discussion. Many of the friends who were at 1122 King Road when police arrived also stayed in the same hotel room on the night of November 13th, 2022. There was also extensive media coverage. Post-event misinformation must be considered as a factor on the accuracy of DM's memory retention. What the defense is seeming to state here is that the police department acted improperly in not separating everyone who was on scene when they arrived minutes before noon. We learned in this motion in limine briefing schedule that one of the first responding officers, Officer Nunez, interviewed DM right outside of the house shortly after he arrived, minutes after he arrived. Then the second interview, which we learned about here a little bit more, took place at the Moscow Police Department, and it was Detective Mowry who conducted that second interview. But we're learning here information that we didn't know. Number one, that they weren't separated, everyone. Number two, they were not told to stop discussing or not discuss what you would think they'd be very wanting and natural for them to discuss. What happened? What did DM see or not see? Would possibly be, we don't know, we weren't there, but it might be a topic for the friends to talk about. We now learn that they all stayed together. They could obviously not go back to their home at 1122 King Road. DM could not do that because it was a crime scene and officers were processing that crime scene. So now we learn that many of the friends plus DM stayed at the same hotel room that night of November 13th, 2022. The defense basically saying this is too prejudicial. This information must be thrown out. It cannot be provided to the jury. We know that the state of Idaho came back very strongly and argues in favor of keeping this evidence in. It will ultimately be up to one person and one person only as to what happens if this motion is granted or if it's denied, and his name is Judge Stephen J. Hippler. These hearings coming up on the 9th and 10th of April for anyone who is interested in this case are an absolute must. This will now conclude this episode of the Indie Zone. My name is Kathy. Thank you for joining us here today.